this outcome and now no longer pursuing an appeal before the Constitutional Court in respect of the Al-Bashir decision in the Supreme Court of Appeal, says, well, we will effect our own extrication. And the extrication we will effect is we will simply issue the withdrawal notice and take the step then of repealing ultimately the Implementation Act. The question that arises is, well, does that achieve the retention of head of state immunity in circumstances where that head of state is accused of international crimes? And our submission is that it does not do so. Perhaps I could then turn to that proposition. There is a recognition in the Al-Bashir case, and importantly in the decision of Justice Wallace, at paragraph 87, where the court explains that under section 39(2) of the Constitution, there are a number of provisions of the Bill of Rights which make it plain that international crimes, crimes against humanity, genocide, apartheid, and the like, those international crimes are crimes by reason of the provisions of our Bill of Rights. And the court references sections 11, the right to life, and sections 10 and 12 of the Constitution. In other words, it is an incident of the Bill of Rights that these international crimes are crimes under our law, our domestic law. So, irrespective of whether we accede to the Rome Statute, and irrespective of whether we domesticated the Rome Statute, both of which we did, the repeal of the Implementation Act doesn't change our Constitution. Our Constitution is supreme, and it requires that international crimes are crimes as a matter of South African domestic law, quite apart from the Implementation Act. That proposition has been affirmed by the Constitutional Court in the Zimbabwe torture case, where at paragraph 37, the Constitutional Court said, along with torture, the international crimes of piracy, slave trading, war crimes, crimes against humanity, genocide, and apartheid require states, and these are the important words, even in the absence of binding international treaty law, to suppress such conduct because all states have an interest as they violate values that constitute the foundation of the world public order. So as a matter of our law, definitively stated by the Constitutional Court and affirmed again in the Supreme Court of Appeal in the Al-Bashir case, international crimes are crimes of our domestic law. Now, the entailment of that is the following, and this too was held by the Constitutional Court in the Zimbabwe torture case, that it is therefore an incident of our law not only that they are crimes, but that the prosecuting authorities are obliged, as a matter of Section 7(2) of the Constitution, as also under the relevant statutes that are binding upon the investigation of crime by the police services, that they must pursue and investigate these crimes. And that too is plainly stated by the Constitutional Court in the Zimbabwe torture case. So we therefore have the following situation that emerges. On the one hand, you have the language of Section 4(1)A of the Immunities Act, which says, just to recall the words, that a head of state is immune and enjoys such privileges as the head of state enjoys in accordance with the rules of customary international law. And the Al-Bashir case has said that as a matter of customary international law, that includes head of state immunity. But you have, as a matter of our own Constitution, the requirement that international crimes are crimes of domestic law and they must be actively investigated and pursued as a matter of our domestic law, and those charged with the enforcement of our criminal law, the police in the first place and the prosecution services in the second place. So how are these provisions of our constitutional law then to be reconciled with the statutory provisions in Section 4(1)A of the Immunities Act? Well, the answer is given in the Constitution itself, and it is given in two places. The first is in section 232 of the Constitution. That says that customary international law is law in the Republic unless it is inconsistent with the Constitution or an act of Parliament. Now, the question that arises is one of interpretation. The language in section 41A would seem on its face to accord head of state immunity, but head of state immunity, as accorded in 41A, must be read subject to the constitutional requirements as to how we read the content of customary international law. Customary international law is not part of our domestic law to the extent that it conflicts with the Constitution. You cannot, on the one hand, criminalize international crimes and require the enforcing authorities, as a matter of domestic law, to pursue those crimes and simultaneously accord immunity to those who are the perpetrators of those crimes. That is the first obvious.
What does that do to your 41A?
What it does.
Is there a question of constitutionality there?
No, and this is Your Lordship presiding asks the question that has been referenced with respect wrongly in our learned friend's heads of argument for the government party. They say that we would then be required to bring a constitutional challenge to the constitutionality of 41A. But we say not at all. As courts have said on many occasions, the first requirement is to try and give a constitutionally compliant reading to the legislative provision. And the constitutionally compliant reading of the legislative provision is a very simple one, which says, of course we generally recognize head of state immunity, but in circumstances where that head of state has engaged in international crimes, our Constitution, as a matter of constitutional supremacy, requires that we pursue that as part of the community of nations that will always take action against those most heinous of crimes and will prosecute them as a matter of our domestic law. And so the supremacy of the Constitution says we read customary international law, which has been incorporated in section 41A, on the basis that it is not part of our law to the extent that it is in conflict with the Constitution.
I understand crimes against humanity crimes under law by virtue of our Constitution.
Yes.
But then you have the Immunity Act. Now, the Immunity Act gives immunity to certain people and heads of state. Of course, you need immunity only if there is a crime. There will be immunity if there is no crime.
Yes. And the Lord say for this, the way in which it is framed by Parliament, bearing in mind that this is legislation which is framed after the Constitution comes into force. It's not an apartheid piece of legislation. It comes into force in contemplation of the Constitution, and the way it is framed is not to say we recognize head of state immunity. No. What it says is head of state a head of state enjoys immunity in accordance with the rules of customary international law. Now, the question that is then arising is, what are the rules of customary international that Parliament intended to incorporate by reference? And it could not have intended to incorporate by reference those rules of customary international law which are in conflict with our Constitution, because that's precisely what section 232 says cannot be the case. So Parliament, when it incorporates by reference customary international law, knows that customary international law that is at variance with the Constitution can never be incorporated in the statute. And so the constitutionally compliant interpretation is one which says, yes, you can have head of state immunity, but not in circumstances where that head of state is prima facie guilty of an international crime, because in those circumstances there is an overriding constitutional obligation to prosecute such persons. And nothing about the legislation would suggest that it intended to try to circumvent the Constitution. There is a second route by which one can arrive at exactly the same conclusion, and it's this, that as the Al-Bashir cases made plain, the reason that international crimes are crimes of domestic law in South Africa arises from infringements of the Bill of Rights, Section 10, Section 9, Section 12, and the like. The consequence of that, as Glenister 2, referenced by our learned friends, makes plain, is that Section 7.2 of the Constitution requires that the state take steps, as it says, the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. So there is a positive obligation to fulfill these rights. And where crimes arise, the most grievous crimes that humanity knows of arise perpetrated by a head of state, at least prima facie, the state has an affirmative duty to honor those rights. That,
Mr. President, in practical terms, how would that work? If the head of state is in South Africa and is being accused of crimes committed elsewhere, how is the prosecution here going to be able to effect that prosecution when witnesses and the scene of crime and everything else may be outside his jurisdiction, without reference to the ICC?
well, in fact, it becomes extremely easy, because once the head of state is in the country, one has jurisdiction over the person of the head of state who has committed a domestic crime. And a person who has committed a domestic crime who is present in the country means there are circumstances where jurisdiction is asserted over them, and the only question is, can they assert as a defense immunity? So they are liable to arrest, they are liable to prosecution for committing domestic crimes because they have come into the country, and all that is left is, can they assert immunity? And our argument is they cannot, because the Constitution tells us that customary international law simply doesn't apply in circumstances of international crime. Now, if I could just complete the submission, and then if one examines Section 7.2 of the Constitution, which is the affirmative obligation to redeem the Bill of Rights and violations thereof, and one then reads Section 39.2 of the Constitution, which deals with interpretation. It says, when interpreting any legislation and when developing the common law or customary law, every court, tribunal or forum must promote the spirit, purpose and objects of the Bill of Rights. So when this court comes to examine the language of Section 4.1a, one has to say of Parliament, in order for the immunity to survive, no, Parliament decided that it was going to accord head of state immunity to war criminals, even though the Constitution makes it plain that these are crimes as a matter of South African law, that there are affirmative obligations not to allow such crimes to take place and to actively prosecute them within the limits of what is possible for our authorities, and it is possible when the head of state is in the country. So the conclusion of this interpretive exercise is that we say, and it is only a question of interpretation, is this, that the right interpretation as a matter of law is that no head of state immunity exists under Section 4.1a for international crimes. Yes, for international crimes. And therefore, to come full circle, the heart of the reason that the state, the government, is taking the step that they are of having the withdrawal notice is unsupported by legality. It is an error of law because they think that it effects extrication, but it does no such thing. And therefore it is substantively irrational, and therefore substantively irrational decisions, as our learned friends have already submitted to the court, cannot stand. They are void ab initio, and they must simply be struck down by the court as a matter of this court's jurisdiction. If I could then simply submit the following, that we therefore, apart from associating ourselves with the other arguments, also associate ourselves with the relief that is sought by the applicant and seek the costs, including the costs to counsel. If I could then simply indicate to the court that the learned friend Ms. Steinberg and I are required to appear in another court in this division tomorrow. We would ask if we might be excused tomorrow. I am leaving the learned friends of the Fremen in court, who will be here should the court have any further matters they wish to raise.
I think we've said we are safe. There's no problem from our perspective.
I indebted to the court. I've also been asked to make a similar request on behalf of the learned friends, Mr. Katz and Mr. Duplessis, if they could be extended the same.
That's why I told you can argue this case in one day.
I don't want to argue the point of the KMI case again, but I've got a similar but slightly different request to Mr. Utahantu.
You said we won't give judgment in this matter.
But my difficulty is that I'm in a leave to appeal tomorrow morning. I presume it will finish quickly enough for me to come and join court.
This in this court?
Not in this particular court, but yes, in this division.
This division?
Yes.
Only if your appeal must start at 9:30 and finish by 10.
Mine actually starts at 9, so I'll quickly finish. But
see you at 10 o'clock.
If I'm not here at 10 o'clock, I've made my excuses.
Thank you, Ron. Is it so that you only want us to listen to you tomorrow? We are here.
I'm also, as you might have noticed, and in spite of all the other appearances, and unlike the other appearances, we're not intending to disappear. So we're entirely in the Lord's hands. I'm very happy to start. Might, Lord, the usual meretricious offer of counsel might focus it more tightly. If we started tomorrow at the regular time, I'm confident we'll finish. We're certainly not going to finish today now. Or if the court requires me to use the court time now, then I shall be picking up as I can on a number of arguments.
I think if it's more convenient for you to start tomorrow fresh, you are confident to finish this time.
Yes, we'll certainly do that.
We would accommodate you. It might be that when you are fresh, it might be much easier to follow.
I might agree with that.
Court address?
Rise. Sana kita untuk sah, kita litip ya hao, litip ya hao. Sana kita. I can't believe it. Now, my 3% is open. Telling you, no.